Hello, everyone. Nick Chavez here, along with my law partner, Martin Valko, with Chavez and Valko, your key to immigration solutions. And we're here today to discuss some major news in the immigration world that has enormous implications, enormous impact in our immigration community. And with all big announcements, there is usually a lot of misinformation. So that is one of the reasons why we wanted to do a show today and also take your questions. But before we begin, let me just say hi to my law partner in crime, Martin Valko. How are you doing, bud?
Good, good. Much better that we've heard the announcement. It's hopefully it's going to get implemented, and it's we talked about it yesterday and talked about it for a little bit, and here it is. Just a great news, and hopefully we'll get more clarifications and implementation, and as President Biden said at the end of the summer.
Yeah. Hopefully, this is something that, and I was talking earlier on a Spanish show about this, and it's something that is going to be evolving. It's going to be developing, and it's going to be interesting what will happen. This announcement came about, and we're pretty sure that there's going to be resistance and there's going to be litigation. But we're here today to help you. If you have any questions about this new announcement, if you have any questions about immigration in general, please feel free. We'll be talking about the Parole-in-Place, but please feel free to send us a message on the screen, and we'll be happy to address those questions. And also, please don't forget to subscribe and to our channels and hit like. This will allow you to stay on top of the latest news. Man, Martin, I'm tired. about an hour and a half talking about this, so my brain's lagging a little bit. So please bear with me. So we're
you're
here.
Doing great, man. I saw you on the other show.
So we're here to discuss this new announcement and this benefit called parole. And every time I'm talking to a person who is not familiar with immigration law, who's not versed with this, when I say parole, they're like, "What?" Right? Because it has a strange name. It has a strange name because we usually hear that term, that word, in the context of criminal proceedings or a sentence. Parole is part of a criminal sentence, so it sounds really bad. But in our immigration world, I mean, it's something positive. It's actually referred to. It means an entry permit. Really, it's a type of status a person has if they are given parole. It's limited. It's temporary. And for the purposes of this announcement, this policy that was announced, the purpose of that is to help spouses of U.S. citizens who are ineligible to apply for their green cards because of their current immigration situation, right? This policy is aimed really at immigrants who belong to, and we hear this term floating around all the time, mixed status families, which means a family that consists of U.S. citizens and immigrants are living together. But for whatever reason, the non-citizen family member is unable to apply or realize immigration benefits because something in the past, immigration violation. Most common is a person who simply had entered the United States without inspection. And we know that as in our immigration world, we call it EWIs, entry without inspection, individuals who entered without inspection. Even though they're married to a U.S. citizen, they're generally ineligible. They can't apply for their green card here. And this is why, it's important to have these shows to clarify, because we hear that, we see in the social media, we see on TV, why can't they get their green card here? Why, what's the problem? They're married to a U.S. citizen. Well, a lot of it has to do with a person's immigration history. Immigration law is extremely complex. It's like it ranks up there with tax law, and all the other intricate areas of tax law, and you got intellectual property, but we won't go into that. But it for people who are given or granted parole, it forms the basis to apply for some well, number one, it gives them a temporary form of protection. That's the thing. When a person's given parole, they can't be deported. It's a protective shield from that. They are also eligible. People who are given parole, also known as parolees, are also have the opportunity to apply for a work permit. Now, when we talk about parole-in-place, really there's two things going on right here. There is the short-term benefit, which is that work authorization. There is that temporary shield from deportation. And then if granted, how can we use that to apply for a green card? And a lot of people, right, Martin, a lot of people come into our office. They are married to U.S. citizens, but they had entered without inspection, they're EWI, and they're ineligible to apply for a green card. Well, this could possibly meet that requirement for those who are trying to apply for the green card here. The main requirement is to show that you had entered with inspection. But if you're given parole, you can meet that requirement. And so that's the whole theory behind parole-in-place. So what are your thoughts about today's announcement, Mark?
No, I mean, it's just, I said earlier, it's just the great news. We speak with clients, but also here, just general public, always talk about, they're here, they can qualify, they can apply for green cards. And that's the difference when somebody's in the U.S. that who entered lawfully, was inspected and admitted with a visa, was paroled in, and is married to a U.S. citizen. Even if 20 years went by, they are able to apply for a green card, right, to adjust their status, or as it's commonly used to apply for a green card. Those that haven't entered lawfully, they were not inspected and admitted, they entered, like you mentioned, EOE, they have to then proceed through consular processing. Typically, they are here for more than 6 or 12 months, which would then make him ineligible because they would have unlawful presence, and that would have to be waived. So, as President Biden had mentioned today, and some other commentator had mentioned as well, this is nothing new, and it doesn't give anybody, some kind of a new right to obtain to apply for the green card. I mean, people that entered without inspection have the ability to go through this process through the petition of the U.S. citizen, applying for the waiver, a provisional waiver, if all that you are trying to waive is unlawful presence, and then go through the consular process through the National Visa Center, and eventually end up at the U.S. consulate or embassy. Now, when you add it all together, you're talking about 5 up to 7 years, depending on which consulate, which country you're originally from, where you have to process it. And that's basically what President was talking about, right? Keeping families together throughout this process. Now, over 10 years ago, under President Obama, the provisional waiver was announced, which is, again, waiving unlawful presence. And prior to 2013, people had to leave the U.S., go to the consulate and submit that waiver, and then wait if it's going to be approved or not. And so if it wasn't approved, then they had to wait outside for a period of 10 years, or wait until a waiver got approved. And so that's basically where we are. So even though the provisional waiver was introduced, they were here. That final step where they go to the consulate or the embassy, for some reason there's a wrong decision by the officer, or something is missing. All of a sudden, a person who was supposed to be out for 5 or 7 days is out for a couple of weeks, couple of months, or even more, depending on if there's additional finding that wasn't known to the attorney. So again, this is people saying, well, he's creating new law. No, parole has existed. We've used it before. We've used it with military families. And so this is basically what he said, what the president said. They are still going through that process. And if there has to be, for example, a waiver that they qualify for, they would still have to get that pardon, that waiver approved here if it's for something else than unlawful presence. But they get to do it here. If something doesn't go right, you get to go to a higher authority, you get to review it, but they're here. Again, they get to stay with their families, with their U.S. citizen spouses. And that's really the difference, right? It's just, I mean, that's how I see it. It's just, it's a great thing. So, some are saying perhaps it didn't go as far as some expected. And I'm not sure if President Biden was trying to be too controversial, to recover too many people. There were some people were talking about that perhaps the spouses or parents of U.S. citizens should have been covered, et cetera, et cetera. Just the fact that they've added the children of the foreign nationals, of these immigrants that would qualify as the children of these U.S. citizens petitioners is a pretty good deal. So if they did not get covered by DACA and their mother or father is able to obtain the parole, so will be the unmarried child under the age of 21 and be eligible for parole, which is, again, that first step where you get this protection for 3 years. For up to 3 years. Apparently that's what the parole is going to be. And as you mentioned, we're waiting for more clarifications and FAQs. And once they have the parole, they're eligible to apply for work visa, for employment authorization for a work permit. And then within that period of 3 years, they can apply for adjustment, to apply for their green card. So they don't have to go through the process and return to their home country.
Yeah. So this is a parole benefit that is designed specifically for spouses of U.S. citizens. They're immigrants. They're living here in the United States. They formed their lives, but they can't or they're unable to apply for a green card for whatever reason. And again, one of the main reasons is because of their immigration history. Okay, so this is an option that could lead in the future to legal permanent residence. And the requirements, again, is you have to show that you were present in the United States without admission. And that's important to emphasize because there's different types of paroles, right? There's different parole programs. Some people are outside. This one, you have to be here physically present in the United States. And you have to show that you entered without admission, meaning that you crossed illegally. You didn't come in with a visa or anything like that, and that you've been living continuously present in the United States for at least 10 years. So they're going back from June 17th to 2024. So that would be since June 17th of 2014, 10 years. You've been living here in the United States. Of course, you're legally married to a U.S. citizen. Legal marriage is very important because we have some clients who get married here, but they were married in the past, and so they have to show that their marriage here is legitimate. And so if they had been married in the past, they have to show that marriage has been terminated. And this is the other part of it is they have to show that there's no disqualifying criminal history. This is where we get into, from the announcement, we get into language that's sort of broad and vague. They don't list specifically what that is. Criminal history, what is that, right? What's the danger to national security? What's that? But they tell us that there's regulations. There's more information on its way to fill in some of that void and answer those questions. You mentioned children, right? So children could be eligible for this parole benefit if they can meet the requirements, and this includes stepchildren. So some people come in the United States, they live here, and they have, they get married, and they bring their own child, and the child doesn't have legal status. Could be that they weren't eligible for DACA or just missed out. Well, your child could potentially be covered by this if they also meet their requirements, the residence requirements, and the relationship between the stepchild and the U.S. citizen step-parent was formed prior to June 17th of this year. We do have a question here from Leo. Leo Alcala says, what about these permanent bars that are included? I mean, are they disqualifiers? And what he means by that is that we know that parole-in-place, this benefit, is going to apply for those who entered without inspection, right? And presumably that's just one entry. They entered without inspection. But what if that person had lived here for over 1 year without any status and leaves the country and then returns and has, multiple entries, right? This is going to apply. This is going to help people with one entry, but is it going to apply with people who've been in and out of the country and are subject to this 10-year bar for having been here in the United States illegally? What are your thoughts, Martin, on that?
Well, I mean, it does not, and Leo, thank you for your question. It does not cure in terms of would the person be able to obtain the parole in place? We don't know yet, and I'm not sure. We're just going to have to wait for clarification. Now, obtaining the parole in place may be a way. I mean, they'll may give it to somebody who's got the permanent bar. We don't know, right? They may give it to them just to give them the parole so they can apply for the work permit. But in terms of being eligible for the next step, which is really the major goal or the main goal of this program, is for the spouses to be able to apply and the children for adjustment to apply for the green card. And so that does not get waived, right? So it doesn't go away with being granted the parole in place. As administration had indicated, it will be case by case basis in terms of whether to grant somebody the parole. But we know that's settled law, and it's basically permanent bar is being inadmissible under Section 212A9C of the Immigration and Nationality Act, which Nick indicated if you cumulatively have more than 1 year unlawfully in the U.S. and then you've been removed under Section 235B1, you leave and re-entered without inspection, bam, you are permanently inadmissible. And that's fairly common scenario where you have people going back, somebody is sick, they go back and they re-enter, and they are inadmissible under that Section 212A9C, which is the permanent bar. So we'll have to see if there was going to be more clarification as far as being granted the parole. But even if somebody is granted the parole, they will not, if they are permanently barred, they would not be able to go to that second step, which is the adjustment of status.
Yeah. So Leo, really touches on two parts, right? The parole in place, the immediate benefit, right? The purpose you apply for a parole in place is to get work authorization and to get this deferral of deportation. I don't want to sound fancy, but basically get protection, get a shield from being deported. And so that is the immediate, that's the short-term benefit. Once you have parole, the next question, the next step is what do I do with it if I am married to a U.S. citizen? Am I now eligible? I don't think the parole will cure the inadmissibility, but I don't know if they're going to give the work authorization, give you temporary status just for meeting the basic requirements. In other words, give you the immediate benefits, the goodies, right? The work permit, the shield against deportation, but not necessarily means that you are going to be eligible for a green card if you're subject to this 10-year bar. Thanks a lot, Leo, for your question. We have another question here. This is from Juan. Juan says, this is information is we need to share it in Spanish and to the Hispanic community. And I agree with you, Juan. If you look at our show earlier, we had a show that started at 5 o'clock and it was in Spanish. So I invite everyone to check that out if you want to you want to learn more about this new policy. Miriam Garza Lee, she's a great associate with us, and we cover that together in Spanish. So we know that they give us an idea, right, of who may be eligible, and as Leo mentioned, we're trying to figure out who is not eligible, right? Uh, we know that some people could be eligible if they meet the requirements. Are there any people that you think are not going to be eligible to even apply for parole in place to begin with?
Well, I mean, we've seen it with military parole in place where people just did not have good moral character. Because again, let's just remember this is discretionary based grant of parole, and if the officer of the adjudicator doesn't believe you deserve it, it's their call. Unfortunately, right? There's really no appeal from a denied parole. You may have certain convictions that would make you ineligible for some certain drug offenses, certain controlled substance convictions that will make you ineligible. And so, again, it's typically if somebody enters legally and they have a criminal conviction that makes them inadmissible, but there's a waiver available, they get to submit it along with the adjustment of status application, and if approved, they obtain their green card, they obtain a lawful permanent residence. So here, like Nick mentioned, it's a two-step. You're applying for the parole, and typically you have to disclose the bad things, right? The convictions and some criminal conduct in the past, convictions, and the adjudicators are making that decision. Do we give them the parole? And perhaps argument could be made that, okay, all right, give him the parole because there's a waiver available at the adjustment of status stage, right? So we'll look at it to see, what type of strategy you can utilize. But that's that kind of a two-step. You're proving, at two different levels that you should grant it, you should obtain it, you should be, given that.
Yeah.
But mostly, obviously, the typical, have you been here for 10 years? Are you married? Have you been married to a U.S. citizen on June 17th, 2024? It appears that if your spouse was a resident on June 17th, I just met with a prospective client the other day who was married to the foreign national for several years, and they took the naturalization exam. They passed it, and they're waiting to be sworn in. So again, person does not become a U.S. citizen until they take the oath of citizenship. But as of June 17th, yesterday, that person was not a U.S. citizen. So I don't think that they would qualify under the information that we have currently. So those are the basic things.
Yeah.
You wouldn't be eligible if like I mentioned, if the person's not a U.S. citizen, and if there are some criminal history in your background that would make you ineligible for the parole.
Yeah, there's some really interesting gray area questions already coming up, and we were asked at the earlier show, but what if, right? What if you are married to a lawful permanent resident as of June 17th, as of the day of the announcement, but later this person, the spouse, becomes a U.S. citizen. In other words, they're in process of naturalizing, and it just based on what the announcement says. That's all we have to go by. It doesn't seem like they would, but who's to say that after the regulations are published and are made available to everybody, who's to say that later on they can't change that to include that type of situation? It'll be interesting. There's other questions too, gray area questions, right? Where there's a person who we know that parole in place is a benefit aimed at those people who entered without inspection, EWIs. What if that person entered, but there's no evidence of? What if they entered with permission with the visa, but they lost their passport, they lost their visa, or they were just waived in, right? And so those are the gray areas. We don't know exactly what's going to happen. We can make the argument for that, but if you had entered, if the person had inspected you, if the officer when you were crossing in the United States said, "Yeah, let me see your your documents and waves them in, then that's an inspection, and by definition, you're not covered by this parole-in-place. But it's again, this is going to develop. We are looking at it from the very beginning, and I'm sure more questions are going to surface, and I'm pretty sure that immigration is also going to come up with answers for those gray area questions through FAQs. They seem to use those after something like this is announced. What about people that, this is for individuals who are married to U.S. citizens. But what if they're not officially married? What if they are married by common law? Does that count?
Yeah, well, I mean, the USCIS just by legally they refer to the state law. So in Texas recognizes state law and the common law marriage. And as long as under the state law the requirements are met, right? Couple agrees to be married. They live together, a husband and wife, and they present themselves to the world, to the rest of the world, as a married couple. That in and of itself forms a common law marriage. And in Texas, I'm not a family law attorney, but what I understand is that you don't even have to have any kind of documentation to show it, or you can go to the county and register your common law marriage. And that's advisable because typically dealing with government officials, they want to see some type of a document. So you can have your common law marriage registered, and you should be able to, if for example, you're not legally, civilly, officially married, but you're common law married, you basically would look at your spouse and said, okay, when did we agree? And okay, was it 3 years ago, 4 years ago? And at that point you establish a date, and you can get it registered. I would also be careful, and because sometimes, just to see if you have the documentation that support that notion that you've been married. So sometimes when we're dealing with immigration court, immigration judges want to know, okay, well then if you're claiming you were married 3 years ago, show me that you had filed taxes together as a married couple. And but most of the people that lived in common law marriage have that type of evidence available. And so again, what's really important here is that it is a pretty difficult, complex area of law. Like you mentioned, often it's compared to the U.S. tax law. And what's important is, if you have doubts, and a lot of these areas are gray areas, is to consult with an experienced immigration attorney, so you can go over all the facts and then determine, is this for you, or are there perhaps other options that the person could seek if they don't qualify for this particular proposed relief.
Yeah. In Texas, common law marriage, there's really just 3 elements. So the short answer is yes. Even if you don't have if you're not formally married, you still would qualify here in Texas, because Texas has common law marriage. And as a general policy, the federal government, with respect to its immigration policies, they defer a lot to what the state does. If the state says it's okay, usually that's fine with the federal government in terms of immigration benefits. So if Texas says that, so you can get married without going to the courthouse and registering your marriage, you could. And that's fine. Common law marriage, just need to show that you're agreed. There's an agreement to be married, that you live together as husband and wife, or it doesn't have to be a husband and wife. It could be same-sex marriage as well. And here's the requirement that I think is the most important one, is that you have represented to other people that you were married. Not just other people. You could say, you could put on your taxes. You could put on your taxes that you're you file taxes as jointly married, that is a representation, and that could meet the requirements of a common law marriage. But speak with a lawyer to see if this argument could be made if you're applying for a parole in place. I have a question here from the listeners. Here is a question from Dallas, Texas. And the person is 30 years old, single parent, full custody, seeking permanent residence. He's been here since 5 or 6. But there's a little, well, you know, it's a little bit off topic, but you mentioned single parent. This policy is going to affect and apply to people who are married to U.S. citizens as of June 17th. But if you have if you want to talk about your immigration case, feel free to give us a call, and we'll be happy to speak with you more in depth about your case. We do have another question here from Ivory Mitchell. She asks, do you think they would consider a drug charge that happened 20 years ago? So, you know, your husband is applying for parole in place. We know that based on the announcement, you know, any criminal history, disqualifying criminal history, so we don't know yet what that means. Would that affect a person's eligibility for parole in place? It could. We have to wait for more information. It also depends on the type of drug charges, and for now, you know, we can look at DACA as an example. You know, they didn't really, when DACA came out, they laid out some of the requirements, and with respect to criminal history, with respect to a person's criminal record, it could potentially disqualify a person from DACA if they had been convicted of any significant misdemeanor or felonies, and the USCIS went ahead and defined what that meant with respect to a misdemeanor. It could be a drug trafficking crime or a DUI. So we're waiting for more guidance, and they are supposed to publish regulations, which we hope could shed more light on that, Ivory. All right, very good. So moving on, we have a question here from Maria Delgado. She is currently our client. Thank you, Maria, and she wants to know if you're part. Well, for cases that we're handling, and I'm sure this goes for with respect to all our colleagues, and we are looking at everything. We're looking at a person's criminal history. We're looking at a person's background to see if they would meet the eligibility requirements. But we also have to factor that in with other factors. As of now, this is an announcement, right? Tomorrow you can't apply for your parole in place. We have to wait for regulations. Once those regulations are published, we can expect that they're going to be challenged in court. So we've seen that with DACA and other immigration programs where you have states, Republican-led states, that are filing lawsuits to block these kind of immigration measures. And sometimes they've had success. So this policy that we're talking about could potentially be blocked. The other factors that we need to look at is, you know, the processing time for this. We don't exactly know. I know some people have speculated that it could take more than a year based on the resources. And so if we have a case that's ongoing, it might be worth it to continue that if it's going to be prolonged. And of course, the elephant in the room, who's going to be our next president, because that matters. This policy was announced and the regulations will be published under an administration that has been moderate with respect to immigration. They've been, you know, placing border security measures and all that, but at the same time, they're willing to extend a hand to those who are here in the United States. Under a different administration, we're talking about Trump, based on what based on what has happened in the past, we can expect him to pull the plug on this type of program. So is it worth continuing that case? Continuing with an ongoing case that you have, it depends on a variety of factors, and it's something that we're going to be looking at with our own individual cases. But it is something that we will consider in light of the possibility of litigation, the possibility of a new administration, and where you are at exactly in the process. Because if you're at the trail end, it might just be worth it to finish it. But that all depends. Thank you, Maria. We have a new question. Well, this one's from Ivory. She extended her question here, and again, this is the drug charge that occurred. A spouse was convicted of a drug charge, wanting to know if he's eligible for parole in place. And again, we're waiting for more guidance on what that means. What does disqualifying criminal history? And that guidance can come through in the form of regulations, which they say they're going to publish for everybody to see. It could come in the form of USCIS making an announcement, a memorandum, as they call them, or policies, and interpreting what that means. What is that supposed to include? FAQs. So I think it's something that we definitely need to wait. How long is it going to take before we get more information? I think that's something that we also have questions about. It could be days, it could be weeks. What do you think, Mark?
I would just add that, well, a couple of things here for Ivory. This is her second post. Is one thing that the drug charges or criminal charges or convictions, even from abroad, even 20 years ago or 34 years ago, they don't go away. So they have to be disclosed to USCIS when applying for these benefits, and then the decision will be based on those. It is important. So if you have a case, if you have these questions, whether it's with us or some other immigration attorneys, you might want to do a consultation, perhaps retain attorneys to do a criminal analysis just to see, where does that stand? Is there currently a ground of inadmissibility, for those convictions? So I can just give you an example. When you're comparing DACA, which is the protection for the childhood arrivals that have been in place since 2012, in order to keep DACA, you cannot be convicted of a DWI or DUI. But that is not a problem with adjustment, for example. So if you're applying for adjustment of status, DUI is not a ground of inadmissibility, and you get to obtain your green card. But in order to keep your permanent authorization, this lawful stay, which is DACA, you can have DACA. But then you flip it, and if you have been convicted of possession of cocaine for personal use, or marijuana, for example, I mean, obviously it depends on the final conviction. There's an exception where you get to keep your DACA, but for something similar on the adjustment of status, would probably not let you get your green card to adjust. So what I'm saying is, a lot of these, everybody has an individual case with individual facts, and it would be important to, even under the current, without knowing what the parole in place will be required, we have an idea of what convictions potentially might be prohibiting, but it could be worth a while to look at it and do the criminal analysis under the current laws, just to know, especially if you have to pull the records and something that you can get ready for. So let's just say everything goes through, and in 2 months or 3 months we have this benefit enacted. You would want to have those records. You would want to have your criminal records and the analysis and everything done. So it may be worthwhile to start pulling those records and doing the analysis.
Yeah. And that what do you include and all that. That might be something that we that changes over time. The other thing that we want to just go over is they give us a list of requirements, and they talk about continuous presence in the U.S. for at least 10 years, since June, that you're physically present here. What do you recommend that while we're waiting for new guidance, right? And we know that this might not happen, but if I were in my client's shoes, I would want to maximize my options. So if I might have something going on the side, or might even have DACA or whatever. But if something like this happens, nothing prevents you from collecting information and documents now. So what I would focus on for clients who are asking about what should they do in the meantime, and even if this parole-in-place gets blocked, I mean, I would start gathering some documents, right? You have to show at least 10 years of physical presence here. And so that could be medical records, pay stubs, contracts, mortgage
school
payments,
records, vaccination records. Yeah, all kinds of things.
If you have, and we won't know, but I would imagine, just based on our current parole request in the military parole-in-place context, if you've had any type of arrest that it was not related to traffic, any citation not related to a traffic violation, they want to see your police records, and they also want to see the conviction records. They're two different things. They want to see what happened. The immigration officer is going to be reviewing and saying, okay, Mr. Smith, was driving, and this was the alcohol level, when he was pulled over. And then they also want to see what happened. Okay, so were there charges raised? Did they present criminal charges? And if so, did the person plead guilty? Was there a plea? What was the sentence? So that's something that immigration would want to see. And if you do have, once we have further clarification on the requirements, it's important to number one, disclose that to your attorney, and number two, get those records certified directly from the office. There might be situations where it's happened here. This happened a long time ago, the drug conviction that Ivory's mentioning. In some jurisdictions, there's no evidence. I mean, there's not evidence, but there's no record of it. They destroy these records after some time. Immigration still wants to see that you've made an effort in getting those records, even if they're destroyed. They want to see a certified letter that, look, we tried to get this, but the court clerk is saying that these records are destroyed and it's certified, and you provide a copy of that. What advice, Martin, do you have right now? And along those same lines, we're talking about the type of evidence they should, but what other advice do you have for applicants that appear to be eligible while we wait for further information?
Well, I mean, you got to wait because there's nothing in place. There's no forms to file. Everything's going to be rejected, as government had said. But just basically everything that you've stated. Book a consultation. Go over your options. If there are no other options currently, then start looking and do your homework, as some would say. If these are the requirements, then start collecting that evidence so you have time, so you're not rushed later on when school is about to start and you have children and you have to take care of them. And so right now, think about, well, let's be positive and say this will be enacted, and let's just start looking. Let's start collecting that evidence. So if it goes through, then you are ready to go. But certainly just kind of take a deep breath and start thinking, okay, so I have this, I have that. Start putting together that 10-year period and most importantly, like he had mentioned, with criminal records in the state, other states, out of state, out of the country, sometimes they're very difficult to get. So there are times where we run criminal background check on clients, whether it will be through FBI fingerprints, where they may not be 100% certain what happened, when it happened, where it happened, and the search will bring that forward.
Yeah.
So certainly, just look at all of your options. That would be my advice, and get a couple of opinions. I've consulted with some prospective clients today where I was just shaking my head about some suggestions that were made by somebody else. So it's important just to go and talk to a couple of attorneys or more and see, well, are they saying pretty much the same thing, or is somebody saying something else? But so look at your options and start getting ready. Do your homework, again, with a positive attitude that this could be enacted, and then you'll be able to request it.
Yeah, and the other additional advice is just to stay on top of it. Subscribe to our channel. We are going to give people some information on this as it goes. As information becomes available, we will dissect it and like we're doing now, and try to make sense from it for you guys. And so important to like and subscribe. And Martin, I think we've come to a close because it's the air conditioning is not working here, and I'm sweating bullets. And but any closing remarks?
Well, you mentioned like and follow. Nick and I had built a platform, and with that platform, there's an app that was developed called Law Pilot, the Law Pilot Guardian, and I think you can find it on any of these portals that we are being transmitted to, where you can sign up, and you get to be connected to us. So if there's going to be any breaking news, anything that you should know about, we will send it to you. It is also loaded with a lot of information about what rights do you have when you are dealing with law enforcement. If you have any emergencies and you have your family connected to it, you are connected to us. So when there is an emergency and you activate this big red emergency button in the middle of it, you tell us of your location, your GPS location on the map, and the app also records the audio, which is uploaded to the cloud for our review. And it's just a fantastic way of staying in touch with us and being protected and being provided with lots of good information. We've just added information about victims. If you're a victim of a crime, of domestic violence, and other types. So on this app, you can just kind of take your time and go through it and find some great information and keep receiving news as they break, or so you can get it here, or you can get it on the app on Law Pilot.
All right. Well, we'll keep in touch with y'all through our social media posts. And again, if you have any questions, if you want to speak with one of our lawyers, we're available. Just give us a call. And don't forget to hit subscribe and like this show. Thank you, guys. Thank you. I appreciate it.
All right. Take care, everybody. Bye-bye.